All right. So as I was saying, this is an old issue. Our experience with the issue has mainly been with medical practitioners working with a teaching hospital. And it seems to me that it's this arrangement that these medical practitioners have with the teaching hospital that have caused CRA concern. So kind of that's the crux of it, is that if you want to get technical and look at your act, CRA is saying under section 37(1), sub A, sub little I, is that when if a group of doctors, say, come together, form a corporation, do R&D, and make a shred claim, that if those same doctors are appointed by a teaching hospital, the company cannot make a shred claim. And what they're saying is that the company cannot make a shred claim because the work is not being directly undertaken by that company. They're saying the work is being directly undertaken by the individual doctor because of that doctor's appointment with the hospital. So they're saying that the company can't even make a shred claim in the first place. So that's kind of at the crux of the whole issue. So what CRA seems to be relying on, and this is why, even the guidance, I doubt when it comes out may even address this issue, because it seems to be based on the documentation. And when I say documentation, I mean these appointments, hospital policy, contracts that might be out there between the doctor and the hospital and the university or whatever. All of these contracts are a little different, and they all say something a little different. But the way CRA is interpreting these contracts is basically saying that it's the university or the hospital that's directing the course of this R&D for the doctor to take place. So our position is that these appointments are merely just that. So if you look at an example of an appointment, a hospital will say to a doctor, okay, we're going to appoint you as head of radiology, for our hospital. And so this is a privilege for you to come in and use the facilities. You can undertake work, but nowhere in the appointment does it direct that doctor to do specific things, and certainly not to undertake any specific research. So these appointments are kind of rights or privileges and guidelines how the doctor has to behave as well. So there's ethical guidelines and things like that that they have to abide by. So these appointments really are just that. And certainly in the cases that we're working on, the hospitals are not paying these doctors. The doctors are being paid through OHIP, okay? And they set up this corporation, so OHIP, fees go into the corporation, then get dispersed out of the corporation. So what seems to be happening is that CRA is taking an added step here and saying, no, there's much more to these appointments. The doctors are having to do research, and the hospitals are directing the course of this research and all of these sort of things, where in actual case, in any of the situations we're working on, the hospital has never said to a doctor, undertake this specific research or anything like that. So it just doesn't happen. So if we look at various positions that are kind of affected by this, primarily we see doctors who have come together and formed a corporation. So they form this corporation, and the corporation receives OHIP payments, so they get dispersed. And with respect to the corporation, we have a combination of individuals who are being paid by the corporation on payroll or being paid on a contract basis. And so the corporation is doing all sorts of things. It's doing just regular hospital or the type of services that they do through OHIP, like if it's radiology because of it's a teaching hospital, they have to do some teaching, usually with the university. Then secondly, they might undertake some research within the corporation, but that's at the direction of the corporation and what they decide to do. Then you have other situations where there could be clinician scientists who are carrying out research alongside work where they're doing clinical care to patients. So again, this is more on an individual basis. And then you have situations where, as I said before, there's a combination of salary and contract costs. With respect to CRA again, we still haven't got direction on it, but as I suspect, I think the direction is going to be probably somewhat vague and maybe very general, and I'm not sure it's going to resolve some of these issues. So again, to reiterate CRA's position, they're saying that this work being done by these MPCs has to be directly undertaken by the MPCs, okay, or it has to be directly undertaken on behalf of another party. So they're saying in this case, it's not being undertaken by the MPC, it's being undertaken by the doctor because of that doctor's appointment and relationship with the hospital. So in terms of some specifics, where we've seen denial letters come out of Toronto, we've got a situation again where they're saying there's no contract between the hospital and the MPC to basically say that it's the MPC that's being engaged to do the RDP. The doctors are appointed by the hospital to perform their duties as doctors and are affiliated with the university. In addition, the doctors are expected, if not required, to do the research. Doing research, they're fulfilling their obligations and expectations with the university or the hospital. So they're saying again, it's that individual who has that obligation, not the corporation. And secondly, our position is that the doctors are the ones who are undertaking the shred and the work performed within fulfillment of their appointment with the hospital or the MPC. Again, I'll come back and say, in the appointment letters, that is not spelled out. It's just not spelled out. And then we see a similar type of denial letter in Montreal by saying, that the doctor and his medical professional corporation are two separate entities. And again, you've got this idea of the responsibility of the doctor for having to do the work for another health entity, and that can't be attributed to the MPC, its corporation, his or her corporation. So again, they come back to relying on these appointment letters. They're looking at publications. That is usually any publication that comes out of the research is usually in the name of the doctor or maybe even the hospital, not the corporation. They say that the hospital university has control over the R&D, but again, we've never ever seen a situation where any of these doctors have been directed to do specific R&D projects. And then there's an idea of the ownership of the IP. Again, what we see in most cases is that the corporation has the right to exploit any IP. There could be a royalty that's payable to the hospital, but in any case, it's the corporation that has the right to exploit the IP. So how do you separate this obligation from being appointed, versus having the corporation make a claim? And again, when we look at this documentation, we don't see any, again, this appointment is more of a privilege to be able to work at the hospital. Again, the hospital is not paying the doctors directly for this appointment. They don't get paid anything for that. They just have the right to use an office, to use the facilities, to use the resources there, all that sort of thing. And in no way is the hospital telling that doctor how to do their job. So if the doctor wants to do research and all these sort of things, that's up to the doctor. And as I said, in most cases, all of these situations that we're dealing with, no one's being paid by the university. The The doctors are receiving their compensation either through OHIP or through the alternative funding plan, which I'll talk about in a minute. Talked about a bit about some of these other things already. So where the corporation is directly hiring and paying fellows as T4 employees to carry out the research, that's being done under the direction of the doctors. And they don't have any university or hospital appointments. So you can have a situation where you got an MPC. Some of the individuals in that corporation have appointments with the hospital and some don't. Some are just being paid by the corporation directly, and some of them are on payroll and some of them are on contract, but yet they're doing RDP. Okay? So what happens in those cases where they're not under an appointment? You know, yet they're doing R&D. Is that a joint project? Is that a joint shred project? Or why would it be disallowed in that case where they don't have an appointment? Yet they seem to be denying the whole thing because of these appointments. So right now we still don't know, you know, what is going to happen here. Again, I doubt that the guidelines that are going to come out are going to be very specific. That's going to give us much guidance, and I suspect that that CRA is going to want to see something go to court so that the courts define what's being done. And I know that that's going to happen in some cases. Whether it's going to get settled out of courts or whether it actually goes through remains to be seen. And I don't know what other people's experience are out there if they know if anything's closed, but I don't think we're going to see anything happen this year where a court would decide upon anything. So I'm not sure how long it's going to take before this issue is resolved. The second issue relates to this alternative funding payment. So where you have a teaching hospital and doctors are associated with the teaching hospital, they have to do additional things that other doctors don't. So if you're not with the teaching hospital, basically, you know, you can do your clinical rounds and things like that. But when you're associated with the teaching hospital, you have to do extra things like teaching. So you'll have to maybe teach a course at a university. There is other areas where you have to integrate the coordination and interest of the medical staff, the teaching hospitals, and universities. So there's some unique things that these doctors have to do over and above what a normal doctor would do. So they came up with this alternative payment plan to reimburse the doctors for this work. Now, again, this alternative funding plan, they differ a little bit from person to person and from doctor to doctor, from hospital to hospital. So it covers a little different. Now, in most alternative funding plans, research is mentioned in the plan that you know, doctors may do research. But again, these funding plan agreements are extremely general. They're very, very general. So they will not say, and there won't be any addendums or subsequent thing where you know, AFP will say, okay, you should do research in this area, or you should do this research project. That just doesn't happen. And in fact, the amount allocated for research, if you do see anything there, what we've normally seen is that it's in the area of like 10% of the work. So a typical breakdown in the appointment letters might be 70% clinical, 20% teaching, 10% research activities. Now, within the research activity, because it's not specific or anything like that, you know, the Income Tax Act, if you look at what needs to be attributed, so if this is considered government assistance that needs to be netted against shred expenses, it should only be netted against shred expenses on an expenditure basis. So again, the Act is talking about relating these payments to specific SR&ED expenditures. So that means to me there has to be a very strong link between this reimbursement and the SR&ED expenditure. So there is a legal opinion floating around out there that says there's a good argument that none of the AFP applies against SR&ED because there's nothing specific about what's being reimbursed against a specific SR&ED project or expenditure. Having said that, you would think that failing all that, there should be a reasonable allocation of these payments against a SR&ED project. So, for example, if you said, okay, 10% of the payments is X that goes against all research, so doctors might have been doing, or these corporations might have been doing research that, relates to SR&ED and research that doesn't relate to SR&ED. And, there should be a proration for that. And the Act would suggest that we need to have a proration. But again, CRA is not taking that position. They're saying all of those payments need to be applied against SR&ED. They're not working through any allocation whatsoever, which just seems to be wrong. So the AFP funds, received are considered to be government assistance, so they have to be allocated against these costs. But again, as I'm saying, that I think there has to be, the Act requires a stronger link, between payments and a particular SR&ED project. So this issue, I think, should be an easier issue to resolve than the earlier issue, just because I think the fair approach would be a reasonable allocation. So, it shouldn't be that difficult to be able to determine what the total amount should be allocated towards this research in general, and then be able to prorate that to the SR&ED project. So I don't quite understand why this is such a big issue, but I would say that, the Act is quite clear that a reasonable allocation needs to be made. So where we are with everything is that there are a lot of objections with appeals. I haven't heard of anything coming out of there that's successful, and I don't know whether the group that's listening today has any comments on that. But I know we are moving towards court cases. So kind of that's in a nutshell regarding those two issues. Dave, I'll turn it back to you for any questions.